Cease and desist letters occupy a central role in modern legal practice, functioning as pre-litigation instruments designed to halt unlawful or harmful conduct while preserving the rights and interests of the aggrieved party. Although non-judicial in nature, such letters possess significant legal weight due to their preventive character, evidentiary value, and capacity to facilitate dispute resolution without resorting to full litigation. Their importance spans across civil, intellectual property, commercial, and even certain regulatory domains, making them a critical tool in both corporate and individual legal strategy. A cease and desist letter is traditionally categorized as a formal written communication from a rights holder, or their attorney, to an alleged wrongdoer, informing them of the identified unlawful or infringing activity and demanding that such conduct cease immediately. Despite its authoritative tone, the document does not, in itself, carry the force of law. Rather, its legal significance arises from its role as a notice instrument. It provides explicit notification of the claimant's legal position and the factual basis of the alleged violation. In many legal areas, copyright, trademark, defamation, harassment, unfair competition, notice alone can have substantial consequences, especially if the recipient continues the behavior with full knowledge of its unlawfulness. A pre-litigation step. It signals the imminent possibility of legal action. Courts often consider whether a claimant attempted to resolve the matter outside litigation, and the sending of such a letter demonstrates good faith, reasonableness, and proportionality. An evidence-generating document. A cease and desist letter may later be used in court to show that the accused party was aware of the infringement or wrongful conduct. Continued action after receipt can be used as proof of willfulness, potentially leading to enhanced damages or statutory penalties depending on the jurisdiction, a contractual or regulatory trigger. In certain sectors, such as intellectual property licensing or digital service operations, the letter can activate duties, escalate compliance procedures, or initiate negotiation mechanisms specified in contractual clauses. Thus, while the document is not binding on its own, its effects often reverberate across the legal ecosystem surrounding the dispute. A well-drafted cease and desist letter must balance firmness with legal precision. Its persuasive and strategic value depends significantly on its structure. Common components include identification of the sender and authority. The letter clearly states who is asserting the claim and under what authority, often through legal representation. The mention of legal counsel adds credibility and signals seriousness. Description of the unlawful conduct. This section outlines the factual circumstances constituting the alleged infringement or wrongdoing. Clarity and substantiation are essential, as overly vague or unfounded allegations may backfire or expose the sender to legal risks. Articulation of legal grounds. The letter cites specific legal provisions, precedents, or rights that support the claimant's position. This may involve intellectual property statutes, contractual breaches, tort principles, consumer protection rules, or privacy laws. Demand to cease and desist. A direct, unequivocal request to halt the identified behavior is the core element. It is often accompanied by a request to confirm compliance within a specific timeframe. Warning of consequences. The letter generally specifies possible legal actions if the recipient fails to comply, such as filing a lawsuit, seeking injunctions, or pursuing damages. Opportunity for resolution. Many letters include a willingness to negotiate, clarify misunderstandings, or reach an amicable settlement. This can reduce hostility and demonstrate a reasonable approach should the matter escalate.